Ready? Good evening, ladies and gentlemen. Welcome to tonight's Board of Appeals hearing. Before we begin, let me introduce some members of town government that act as advisors to this board. To my left is Valerie Manzo, counsel to the board. To her left is Allison Murray, a planner in the planning department. To her left is John Bongino, town building director. Now let me tell you why you're here tonight. New York State statute requires that any town that adopts zoning must also have a board of appeals to act as a relief valve so that those persons aggrieved by strict application of the zoning ordinance can seek relief without the expense of going to court. Town board can give Board of Appeals additional powers such as special exception approvals, site plan approvals, etc. In Smithtown, the town board has given this board authority regarding certificate of existing use and some special exception uses. The most common kind of application before the board are area variances. Area variance dealt with dimensions such as frontage, height, setback, and parking spaces. New York State statute mandates that the board must consider the following 5 criteria in area variances. When you come to the podium to present your application, you need to address these 5 areas. They're posted here for you. Number 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be produced. Number 2, whether the applicant has other feasible alternatives. Number 3, whether the variance is substantial. Number 4, whether an adverse impact on the environment will be created, and whether the alleged difficulty is self-created. The statute requires the board to balance the interests of the applicant and those of the neighborhood or community. This statute further requires that the board shall grant the minimum variance shall deem necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions for granting variances. Special exception applications are different than area variances. When we have a special exception application before us, I will explain the criteria. Regarding procedure, cases will be called in order they are advertised. When you come, when your case is called, please come forward, submit your affidavits and mailing receipts to Mrs. Murray, and then you will be sworn in at the podium and be given the opportunity to explain to the board why you need the variance. After the applicant is done speaking, all interested parties will be given one opportunity and only one opportunity. So please organize your thoughts, keep your remarks factual that are related to the case. Then I will ask the applicant to come back to the podium to answer your concerns. The board will then close the case and reserve decision. After all the hearings are closed, the board will review the cases and decide some of them. Others will be reviewed at a later date. There are 3 ways to find out the results of the case. You can wait until after the public hearing, but there's no guarantee that the board will act on your case tonight. 2, you can call the planning department tomorrow afternoon. And 3, applicants can wait and be notified by mail. We do have adjournments, so let me tell you what the adjournments are. Case 16566, Francis and Deborah Grease. It is on 12 Salt Hay Way, Smithtown. Was there anyone interested in that case? That has been adjourned to February 14th. The next case is case 16524, 155 West Main, LLC. That's Arthur Avenue. Is there anyone here for that case? That has been adjourned to January 24th. Case 16526, Joseph Legallo. It's on 28 Pulaski Road in Kings Park. Anyone for here for that case? That has been adjourned to January 24th. Okay. First case for tonight is case 16556, Hallie and Selnina Sokinsa Soshkanisket. Wow. 2055 Jericho Turnpike, Comac. Location, north side of Jericho Turnpike, west of Beechwood Lane, Comac. Property zone NB. Request variance to increase the maximum awning height from 12 feet to 18 feet. Increase the maximum wall sign height from 15 feet to 18. Increase the width of the bottom flap of an awning from 8 to 16 inches. Increase the maximum projection of an awning from 4 to 5 feet. Permit lighting on the awning other than on the bottom flap. Increase the number of wall awning signs from 1 to 2. Permit wall awning signs above another wall sign, awning flap. Permit awning sign to be attached to another than the wall or eave. Decrease the wall sign setbacks from the building sides from 1 foot to 5 feet. Increase the maximum ground sign area from 32 to 64 square feet. Reduce the minimum ground sign setback from property line from 5 feet to 2.
Good evening, Madam Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. I've submitted the affidavits of posting and mailing to Allison. I'm sure that most of you are familiar with the Thrifty Beverage store. It's in Comac, and obviously it's on Jericho Turnpike, as you can see from your site plan. The building is set back at its closest point to Jericho, 42 feet. It was a building that was constructed many years ago. Believe it or not, it was a fence company that built it. Then later on, it became a vegetable place. And then finally, my clients purchased the place and made it a beverage store. I know at first blush, you look at these requests for variances and you say, wow, there are a lot of variances. But I think we have to consider a number of things. Number one, the height variance requested from 12 to 17 feet is really not indicative of any substantial encroachment on the road or on neighboring properties, as they're all commercial on the east and the west side and across the street. You've recently granted a variance for awning signs when we came in on Uncle Bacala's, which is down the road west of here, maybe a mile, and you granted flap variances as well as, I believe, variances which allowed side awnings. The building and its display of signs really doesn't have an adverse effect on the character of the area. It's a business area, and it's surrounded by, well, not surrounded, but on each side and to the south are all businesses. There's King Cullen Shopping Center. It's known as the, not King Cullen, but Mayfair Shopping Center. Mayfair has a giant sign out in the front, and some of those stores within that shopping center have sign variances, height variances, some of which I was fortunate to have participated in. So we're not looking at a situation where it would look out of place. Is there some other feasible method? Well, I guess we could eliminate some of those flap signs and paint over the advertising of beverages and so forth. But I think we should also remember in this state of the economy, with the type of competition most people have in the retail business, they need to be noticed. My client needs to be noticed. He's competing with King Cullen. He's competing with other supermarkets. So he needs this noticeability. And as I said, it's set back. It's not something that's hovering on Jericho Turnpike. The freestanding sign, as you can see, and I'm not sure, but if it calculates the way I think, at one point, Jericho Turnpike was widened even down here in Comac, and that's what made the sign closer than normally it would be. In any event, that sign was built many years ago, and the request for double the size really is, as we all know, the thickness of the sign. And if it was less than 12 inches, I wouldn't be asking for the 32 square feet to, I believe it was 64 square feet. The setback, as I just mentioned, from 5 to 2 feet, I believe that was a result of the road widening. And even if it isn't, if you look at your site plan again, it's well away from the right-of-way, the curb line of Jericho Turnpike. So there's substantial distance between the sign, the freestanding sign, and the curb. So it doesn't infringe on the state right-of-way, which we do have those situations in other places. So we ask the board for its favorable consideration. Those awnings have been up for many, many years, albeit there weren't any permits on them. Nobody seems to have been adversely affected by it, and I don't know that there's anybody here tonight that would have an objection to it. It's a beverage store. That's it. It doesn't sell anything else, and if it doesn't sell its share of beverages, we're going to have another closed store in the town of Smithtown. So we ask the board for its favorable consideration. If the board has any questions, I'd be happy to try and answer them.
All right. Mr. Tramarko, we did visit the site. Let me go to planning first, and then we'll ask another question. Planning, do you have?
No comments, no.
All right. The only thing that we noticed, Mr. Tramarko, that when we went, there were lights on the top of the building. I don't know
Well, if
where
they
they're
don't conform,
shining. I don't know.
we're in the process of applying for certain building permits, which I'm sure Mr. Bongino is aware of. If those lights don't conform to town code, we'll change them.
Okay. All right. Gentlemen, is there anything else?
No.
Okay.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Readily moved and second. All in favor?
Aye.
Aye. Motion carried. You're welcome. Next case is case 16557, James Cole Roser, 45 Half Hollow Road, Comac, New York. Location, north side of Half Hollow Road, south of Summers Lane, Comac. Property zone R43. Request variance to reduce the minimum front yard from 60 feet to 55 for a proposed 92 square foot covered front entry.
Hi, my architect, Greg.
First of all, let me have your name
Hi, I'm James Cole Roser,
and your address, James.
45 Half Hollow Road in Smithtown, Comac.
Okay. Raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. Now, would you like this gentleman to speak for you?
I would like this gentleman to speak for me.
Okay. Now, let me have your name, and I'm going to ask you to spell your last name.
Okay, good evening. Gregory Basmajian, Basmajian. I'm the architect for the project. My
And
address, 6
Go ahead.
Banbury Lane in Comac, New York.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you so much.
Well, we're here tonight to seek relief from the required 60-foot front yard setback. My client, the Colorasas, just recently purchased the residence and planned some improvements, one of which is a renovation to the exterior of the home. As you can see, the drawings that you have and the board that I have here in the federal style. The house is currently located, the house was built in the late 60s, I believe, currently located right at the front yard setback. So in doing the exterior renovation in the federal style, the traditional covered front porch, which is what we are here for, consistent with that federal style, will encroach into that required 60-foot front yard. We feel the renovation is in character with the surrounding neighborhood. The home, as you can see, is located on Half Hollow Road, but actually this end of the road is a cul-de-sac. Therefore, we don't think this is of any major consequence, asking for the relief from this setback requirement. As well as environmentally, the porch, which is on grade, is permitted. We're just really here to seek relief for the overhang above the porch. And if the board has any questions, I'd be happy to answer.
Planning?
Thank you.
Gentlemen?
Question.
Okay, thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Really moved in second. All in favor?
Aye. Aye.
Aye. Motion carries. Next case is case 16558, John Randazzo, 51 Holly Avenue. Well, that's not the location. The location is north side, an unnamed, unimproved street, east of Wildwood Lane. That you? Sure. Sure. Pardon me? Yeah. You don't want to do it yourself? You know, why don't you give it a shot? Instead of having this, you don't know how long he'll be out? All right, let's do this now. We'll guide you through this. Let me have your name and address.
John Randazzo, 53 Wildwood Lane, Smithtown.
Okay, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes.
Okay, let me read it now. And it's request variance to reduce the minimum front yard setback from 40 feet to 32 for proposed front porch. Alter environmentally sensitive land, depth to groundwater is equal to or less than 10 feet. Okay.
Correct.
Now, just tell me what you want to do, why you need the variance.
We would like to add a proposed front porch for handicap accessibility. My father-in-law has MS and is refined to a wheelchair. We really have no other way to get him into the house. We feel like what we did propose is more, I guess, easily accessible rather than building a wooden ramp. We try to do everything tastefully, you know, by building out the front. We're going to do a hydraulic lift into the front, which won't be seen from anybody but us. I really don't think it's that much of an eyesore. Actually, I don't think it'll be an eyesore at all, since we do have a pretty nice setback off the main road. You know, I have it at my prior residence, and I think it would be, you know, it's less maintenance, doesn't look like, you know, you're trying to do too much. So we figured we'd try and do it tastefully, and I think it would be actually a nice addition to the neighborhood.
Okay. Planning?
Just so that the board knows, the setback from Wildwood Lane is, the porch would be set back about 85 feet from Wildwood. So that's the street. that you'd be able to see it from. The front yard that he's requesting a variance for is really, it's from a paper street.
Any other questions, gentlemen? Okay,
Thank you.
you're welcome. You don't need the adjournment. Okay. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing. Oh, what?
I believe the engineer had the affidavits for the posting and,
Oh.
We just got those.
so if we can get,
Yeah.
yeah.
Do you have, where your engineer has everything? All the affidavits and everything?
Okay, if you can have him, or if you can get it from him and bring it to the office tomorrow morning. Thank you.
Okay, all right. I don't know why he needs a variance. Anyway, a handicap. Okay. Right, was there anyone that wanted to be heard? Okay, I'll entertain a motion to close the hearing.
So moved.
Second.
Really moved in second. All in favor?
Aye.
Aye, motion carried. Next case is case 16559. Ann and Frank, is it not? Okay. 72 Shirley Court, Comac. Location, south side of Shirley Court, west of Wyandanch Boulevard, Comac, property zone R10. Request variance to reduce the minimum side yard from 12 feet to 5 for an existing 162 square foot covered patio and a 33 square foot breezeway to a garage. Reduce the total side yards from 28 feet to 20. Variance to reduce distance to any lot line from 3 feet to 0 for an existing deck. May I have your name, please?
Ann Kistelth, and the address we're requesting is 72 Shirley Court in Comac.
And are you going to speak?
Yeah, you're going to
Yeah, I guess he's chicken.
She always speaks.
All right. Who's ever going to speak, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Okay. You want to tell us why you're here?
We're here, we sold our house and we applied for a variance because we had to get a CO for our shed. And when the inspector came, he looked at the roof and told us we need a variance. So we're requesting a variance for the roof that we put on. It's been up for about 6 years. And the breezeway roof has been up about 45 years. I owned the house for 40 years. And then what else? And then the deck is up against the fence, and we're requesting a variance for that. It doesn't bother anybody. It's a beautiful addition to the house. Nobody sees it except us. And it doesn't, there's no problem with any kind of hazards or anything like that. It's just a nice addition to the house. We didn't know that we needed a variance.
Planning?
No comments.
Gentlemen?
Awesome, thank you.
Okay. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Really moved in second. All in favor?
Aye.
Aye. Motion carried.
Thank you very much.
You're very welcome. Next case is case 16560, Christopher and Maria Belloc, 84 Twin Oaks Drive, Kings Park. Location, west side of Twin Oaks Drive, south of Country Oaks Drive, Kings Park, property zone R15. Request variance to reduce the minimum front yard from 45 feet to 42 for an existing 96 square foot portico. Reduce the minimum side yard from 16 feet to 12 for an existing 126 square foot covered steps. May I have your name, please?
Christopher and Maria Belloc, 84 Twin Oaks Drive, Kings Park.
And your name?
Maria Belloc.
Will you both raise your right hand, please? You swear to tell the whole truth and nothing but the truth?
Yes.
Okay, you want to tell us why you're here, please?
We're here to reduce the front yard to an existing portico that we.
Wait a minute, do you have all your affidavits and everything?
Yeah,
Okay, let's hand those in first.
the board is
Make
back
sure.
there if they need it.
That's okay. You can take this also. This is fine, thanks.
Go ahead.
All right, on the front, the
Use
40,
go in front of the mic, so you're using the mic, please.
on the 45 to the 42 is a portico that was existing when we purchased the home. That's the variance we're looking for there. And on the side is I guess an overhang over the basement entrance is the other variance we're looking for, 16 to 12.
Did you just put up that cover over the,
Yes.
planning? Gentlemen? Okay.
Thank you.
Is there anyone here that would like to be heard on this application? All right, come up, people, please. May I have your name and
Name is Eugene Blum.
spell your
and
last
the
name,
BLUM,
your address?
82 Twin Oaks Drive.
Okay, and raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
Yes.
Okay.
My concern is on the side stairway cover-up. It's a rather large structure. It's adjacent to our backyard. It's approximately, from the ground level, it's approximately 12 feet high. It's almost a building. And according to the application, it's existing. Existing to me means that it's completed. This is not completed. So my other concern is that what is it going to look like when it is completed? There's no banisters on it. There's no guardrail on it. It's just an open structure. I have a copy of a picture that I had taken some time ago.
Yeah, we have the same thing.
As you can see, it's
Yeah, you have to,
well
you need to go back to the microphone, please. Go ahead.
That's just my concern about, what is it going to be like at the end of the day? Being that it is a rather large structure. It's not just a cover-up. Is it going to be enclosed? If it is enclosed, then it can be an auxiliary shed.
Okay, I'm going to ask all those questions. I'll make
Okay.
you come back up. right.
Other than that, as far as the front application, I have no problems with that.
Okay,
Seems fine.
okay. Did you want to speak? Come up, please. May I have your name, please?
My name is Robert Geddes,
Spell your last name, Robert.
Geddes,
Your address?
86 Twin Oaks Drive.
Raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
I do. I just have a written statement.
Go ahead.
Good evening, board members. I'm here tonight to oppose the request of the variance of the home of 84 Twin Oaks Drive. I appeal to the board to please deny to be able to reduce the side yard from 16 to 12 feet for the existing 126-foot square foot covered steps, which I believe leads to a basement apartment that has been rented in the past, and I would be so inclined that if it's not already rented, we rent it again. Also, I would like to inform the board that the existing accessory building, which was constructed on the highest part of the ground of the property, in my opinion, does not comply with the town code of a residence R15 with the structure should be a minimum 8-foot distance from any lot line. I have some pictures to show that would show this as accurate as I could make them. The accessory building in the yard can be seen practically from any position in my yard, summer or winter, to include every rear window in my house. I feel that
Excuse me, let me stop you for a second. Are you talking about the shed?
Yes,
From my understanding, it is 8 feet from the property line. That's where we have the measurements from.
I question that. I have some pictures that I could show you.
Okay.
Would you like to
What
see?
do you think it is?
I think it's about 5 feet.
Okay. Just let me tell you this, that I'll look at the pictures and everything, but that's not part of this application. If the building department feels that the shed is not in compliance, they're going to have to come back for variance. But that's not part of this application tonight.
Yeah, it was under my understanding that it was able to speak about anything on the property right now.
No, you only can speak about what was advertised. All right? But if you think the shed is, then they will look and see, and then they'll have to reapply if it's not in compliance.
Would you like to see the
Sure.
pictures?
I'll look at the pictures. That's not a problem. Are they labeled for any reason? Or I'll give them back to you, and then if you got to go back to the microphone. This is the picture of the shed?
Yes.
Okay. All right. You want to look at these? And then I'll give these back to you so that you have them. All right. All right, is there anything else?
No.
Okay. All right,
Thank
thank
you.
you. Is there anyone else here? Right. Come on back. Okay. Couple of things. Let's go over some things, first of all. What are you doing with this? Is this finished, or how is it going to be done?
I haven't completed it yet until I get the go-ahead on the approval on the permit. I will finish it.
What does the finish mean?
We were told not to do anything until we had
No,
a
we're not going to
variance.
enclose it.
So,
It's everything,
Stay open the way it's shown here?
yes.
yeah.
It's to prevent rainwater from
From
draining into the basement.
It's,
It's
it's
an-
going to be
it's-
completed with.
On that side of the house, there's not a soffit or,
Fiberglass.
Yeah, one, yes,
there's
exactly.
no soffit or there's no gutters on the right side of our house. So there's an overhang this is the overhang that you have photographs of. This is my photograph. I don't know what that photograph looks like. This is the photograph of it.
We have the same thing. You can take this back.
I didn't know what you were looking at. Once we go ahead and get the variance, then whatever suggestions that is made to complete it, we will follow the suggestions and we will complete it.
It'll probably look similar to the shed when it's done. An upgrade, not a downgrade.
Okay. Just let me tell you, your shed is not on this application, but you might, the building department may go out and look at this shed.
Okay, no problem.
When we submitted all the measurements to the building department, they directed us in what we needed to do, and they made the recommendations that we just needed for the front portico and the side overhang.
What's
They
in
did not-
what's in the shed?
Tools.
Lawn equipment.
I actually enclosed a picture of the interior of shed to the building department, and they said that wasn't necessary.
Is there electricity in the
No.
shed?
No.
It's on a second tier. It's on, our property goes up on a hill and then it goes up 10 feet. There would be no way to get water or, you know, to make it a livable structure. I did it like that so it would comply to the neighborhood. It is a very nice neighborhood, so I built a shed that looked right for the surrounding area, you know?
Okay. All right. Thank you.
Thank you.
Thank you.
Come on back and get your pictures, please. Not you. They'll go out and look. They'll go out and look. Thank you. Okay. I'll entertain a motion to close the hearing.
So moved. Second.
Is ready, moved and second. All in favor?
Aye.
Motion carried. Next case is case 16561, Patrick and Deborah Allen, 283 Woodlawn Avenue, St. James, New York. Location, north side of Woodlawn Avenue, east of Cambine Avenue, St. James, property zone R21. Variance to reduce the minimum front yard from 50 feet to 0 for an existing 5 and 6 foot PVC fences. And your name, please?
Deborah Allen.
Use the mic, please.
Deborah Allen,
And your address, Deborah.
283 Woodlawn Avenue, St. James.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you.
Okay, we're requesting a variance to reduce the minimum front yard
Use the mic. Get that mic so it's
from
done.
50 feet to 0 feet for an existing 5 and 6 foot PVC fence. The fence is constructed on the same property line as the survey that we have from 1978 when we purchased the house. Our property is set back 20 feet off the road to begin with, and then the fence in question is the first 50 feet, which runs alongside the driveways on either side of the house, and then small sections of fence that run in the front of the house, and I think you have pictures. There are hedges that run the majority.
We were there.
Oh, you were, okay. And so we think it's attractive. We really know, after living there for 30 years, Woodlawn Avenue has changed. It's very busy, and so we were hoping to achieve a little bit of privacy, and so therefore we constructed the type of fence that it is.
Okay. And you said when you bought the house, the fence was there.
Yes.
I get-
the fence.
Well, you're still responsible. Probably had no permit or anything for the fence.
Oh, I don't know. My understanding was that it was there for a very long time. The house was built in 1953.
Yeah, okay. I don't know how the other board members are going to vote. I mean, there are 5 votes here, but let me just tell you, we may condition it, and the recommendation is that you do not extend the fence anymore in the front, that you leave those trees,
Oh, the hedges, yes.
the hedges.
Okay.
Okay.
Is that what you mean by condition it?
Yes.
Okay,
All right? Because then it's not even open.
right,
And I don't know if that's going to happen. I'm just telling you that might be one thing.
okay.
Now, you also have another problem.
I do.
Yeah. You have to come back for the shed,
Okay,
okay?
sure.
Because your shed, I don't think you have a permit for the shed.
No, they've been up a long time, too. Now, may I ask a question about
Sure.
sheds? As far as the foundation is concerned, if that's on just plywood rather than a concrete foundation, is that also a problem? Would it be considered temporary?
No, what it's built on is not an issue. It's the square footage. Any structure over 50 square feet, whether it's built on the ground, on a concrete foundation, on block, would require a permit. I also just quickly checked the property card, and I don't see a permit or CFC for a shed.
So then I will come back, that will be a separate issue,
That is
obviously, from the fence.
Is this R10 or
R21.
R21? So the sheds are only, they're 6 feet away, and they need to be, is it 12?
16 feet away.
16 feet away from the property line.
16 feet?
The problem with the sheds right now is that they're in what's considered to be your required side yard. If they were moved closer to your rear property line, they could be as close as 8 feet to the property line. But being that they're in your required side yard, they have to be 16 feet from the side property.
And how far back does that side yard go, when you mean in terms of moving it to the back, because it's an acre of land, so how far back are we
Right.
going?
Within 75 feet of the rear property line is your rear yard. So once you get further than that, that's where your side yard starts. If you want, I can show you afterwards where you could move the sheds to.
Okay, oh, thank you very much.
All right?
Yes, thank you.
Okay, thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Is really moved in second. All in favor?
Aye.
Aye. Motion carried. Okay. Next case is case 16562, William and Patrice Swain, 8 Country Oaks Drive, Kings Park location, west side of Country Oaks Drive, north of Twin Oaks Drive. Kings Park properties are 15. Request variance to reduce the minimum front yard setback from 45 feet to 42 for an existing 228 square foot covered porch. Reduce the minimum side yard setback from 16 feet to 3 and total side yards from 34 feet to 25 for an existing 151 square foot shed. Increase the maximum paving in the side yard from 25% to 30%. May I have your name, please?
My name is William Swain, S-W-A-N-E.
And your address, please?
My address is 8 Country Oaks Drive, Kings Park, New York.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
All right. Would you like this gentleman to speak for you?
I certainly would.
Okay. May I have your name and address, please?
Sure. My name's Robert O'Shea. I'm an architect at 821 West Jericho Turnpike, Smithtown, New York.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Okay. Want to tell us why you're here, please?
Sure. I'm here this evening to assist Mr. Swain in obtaining some building permits for items that were built back in 2005. At that time, a front porch and a storage shed were constructed that we have made applications to maintain these structures which do not comply with the zoning regulations. The porch is set back 42 feet from the front property line, where 45 is the required minimum. It is a completely open-sided structure having no visual impact on the neighborhood. Front porches have become a very popular thing with people improving their homes. And since developers tend to build their houses at or very close to the setback line, most porches require a front yard variance. Thankfully, this and other municipal boards have recognized this and have been receptive to this type of application. I would like to submit copies of 2 BZA decisions from Smithtown that I had something to do with in the past. That this board did grant the variances for. They are case number 15480, which reduced the minimum front yard from 45 to 36 feet. That was around the corner on Cedar Place. And case 13545, which reduced the minimum front yard from 45 to 39 feet at 10 Country Oaks Drive, which is immediately to the south of this property.
Thank you.
Okay. Now, in order for a permit to be issued for the shed, two variances will be required. One for insufficient side yard setbacks, and the other to permit an accessory structure in the side yard. As part of our application, I had submitted some photographs of the backyard, which show a rather tall timber retaining wall, which was built and CO'd in 1974, and also an in-ground swimming pool, which was built and CO'd in 77. These structures left very few options for the placement of a shed. The first option being its current position, and the second being in the rear corner of the property. This second option would require people to travel up a series of steps through the retaining walls in order to access the shed in that position. This would certainly not be a suitable location for a building whose sole purpose is to provide a storage place for pool toys, outdoor seat cushions, barbecue utensils, and things of that nature. The final variance being requested would increase the paved surface from 25 feet permitted maximum to 30% in the north side yard. Since the time that this house and the community was built, people just have more cars. They have children at home with cars, commuting to college, and we need to provide a place to store these vehicles, off the street. This brings up that there's a peculiarity in the zoning concerning particularly side yard pavement. You're permitted to have a 3-car garage in the rear of your property, but you need a variance to build the driveway to get to it. Also, you can have a side entry garage, which is yours as a matter of right, but you need a variance for the driveway to get in and out of it. So
Yeah.
it's one of those odd things that
You don't make the ordinance.
that sends people here.
Yes, sure.
Okay. Now, I mean, I understand the need to limit impervious surfaces on properties. However, this paving limit really needs to be addressed so that at least one of the 2 side yards can be increased to allow residents to provide parking spaces or simply to access these types of garages that I've just described for you. We're not asking for anything that is uncommon in the neighborhood. So the improvements do not have any adverse impact on the community, nor do we feel they are substantial in nature. I think I've demonstrated that the benefit cannot be achieved by an alternate method. There is no negative impact on the environment since the property is not located in any of the town's mapped environmentally sensitive areas. The hardship, although it was self-created by building the improvements without the benefit of a building permit, I'd like to say that had I been advising the Swains back in 2005, for the reasons I've just discussed, I would have recommended that they apply to this board for the variances that we're requesting here this evening. I'd also like to submit 6 signed statements of consent from neighboring homeowners. I have them from number 5, 6, 7, 10, and 12 Country Oaks, and number 2 Mountain Laurel Lane. And the letter reads, I, being a resident of Kings Park and an owner of property within 200 feet of Country Oaks Drive, have seen and understand the plans for which a variance is being sought, and hereby encourage the board to vote in favor of the application. I would like to point out also that 2 of these documents are from the neighbors immediately to either side of this property. That pretty much sums up what I have to present here tonight, so if the board members have any questions, I'll certainly try to answer them.
Okay. There is one issue that you're going to have to take care of. You have a fence in the rear yard that is on town property.
Okay, I know that was pointed out to me at planning, and I suspected that that would be addressed here this evening.
Okay, so that has to be removed and put onto your property,
Of course, okay.
okay? All right. Planning,
No comments.
gentlemen?
Nothing, thanks.
Okay.
Okay.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Readily moved in second. All in favor?
Aye.
Aye. Motion carried. Okay, your turn. Next case is case 16563, Peter Scalavla, 1 Grandview Lane. Smithtown location, northwest corner of Old Willets Path and Grandview Lane, Smithtown, property zone R21. Request variance to decrease the swimming pool required from all dwellings from 10 feet to 9 feet.
Madam Chairman, members of the board, my name is Vincent Tramarco. I represent the applicant. What happened here, we threw down our old house, built a new house, supposedly in the same spot, but when the builder looked at it, he felt that the existing swimming pool might put some pressure on that rear wall. If you look at the survey, you'll see that. So instead of doing an 8-inch wall, he did a 12-inch wall in order to beef up the strength of the wall, and therein lies the variance. Were it not for the thickness of the wall, we wouldn't be here tonight. I actually went out and measured because I said, gee, that's only 4 inches. How can we gain those 4 inches? But as much as I stretched the tape and tried to measure from the coping and so forth, we need a 4-inch variance, basically, and we asked the board for its favorable consideration. I don't think anybody in the area is going to notice the difference, whether it can be achieved by some other method. The house is built, it's up, it's done. Whether it's substantial, it's not, it's 4 inches.
What does that have to do with it? I'm
it is
sorry,
what
Mr.
it is.
Tramarco.
What?
Isn't it to the dwelling?
Yeah.
And not to the retaining wall?
No, if you look at it, there's one point where
I'm
it's
sorry.
9.8 from the house to the pool.
Yeah.
And that's why we need the variance. You've been kind enough to give me greater variances with swimming pools, so we asked the board for its favorable consideration. I won't waste any more time
2
on it.
inches? 2 inches? 4? Okay,
Thank you.
you're welcome. Four inches. Okay. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Ready, moved in second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16564, George Gould, 43 Avenue B, Kings Park. Location, east side of Avenue B, north of Pulaski Road, Kings Park, property zone R10. Request variance to reduce the front yard setback from 40 feet to 23 feet, 29 feet existing, for a proposed second-story addition and a 48-square-foot portico. Reduce the side yard setback from 12 feet to 10 existing, and total side yards from 28 feet to 21 existing. Increase the maximum gross floor area from 25% to 32%. And your name, please.
George W. Gould IV, 43 Avenue B, Kings Park, New York.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do. So basically what I'm trying to do with the house is I was born and raised there, and my dad passed away, so I took over the house, and I got my son, George V, King George. So anyway, what I'm trying to do is the house was built in 47. I believe my parents took it over in 76, and it hasn't really been touched since. So really what I'm doing is redoing the house and making more living space for me and my family. The portico in the front, I am just doing it because, you know, the look of the house, and my neighbor has the same exact one next door. The second-story addition basically is to get rid of the crawl spaces so you don't walk into a wall in the room, you know, when you're upstairs. And that's basically where I'm at.
Okay. Usually, and I'm just going to say this, we don't go over 30%. However, this is very different because it's a very small lot. And I think planning will tell you that you're counting the garage into that 32%. Am I correct?
That's right. If I could just say one more thing, I'm sorry, I was gone for a few
I'm
minutes.
sorry, go ahead.
Do you have the affidavit of compliance, which shows the people that you mailed the mailings to, the notices to? There's two affidavits. One of them is the posting, which you've given me, which says that the sign was
Yes,
up.
I can give it to you tonight. I believe I have it in the car.
Okay.
Okay. Okay.
But I'm sorry, in answer to the question, yes, the garage does get included in the calculation of floor area.
Do we know how big the lot is? Is it, what, only
50 by 130 is my lot.
50 by
And
130?
the house doesn't even meet the zoning, because for anything at the front of the house has to be 40 feet off of R10 zoning, and the
Mhm.
house is 29 feet.
Okay.
You know, the house doesn't meet any part of zoning.
Do you know when the house was built?
47.
Oh.
My neighbor is first one in his house, and my aunt's mother-in-law passed at 106, and she lived across the street. So
Wow.
I know a little history of the block.
Very nice. Wow. Okay. Is there anything else, gentlemen? Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second?
Regularly moved and second. All in favor?
Aye.
Motion carried. Boy, is he getting paid tonight. Next case, case 16565, EDK Holdings, LLC, Stephen LaPiccolo, 345 Oster Avenue, Hopog. Locations outside of Oster Avenue, west of Adams Avenue, Hopog Property Zone LI. Request variance to reduce the required parking from 84 spaces to 64 spaces for 3 existing mezzanines totaling 1,819 square feet.
Good evening, Madam Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. As you can see, there's a plot plan, and it was prepared by Phil Pandolfi, architect. I'm sure you all know Phil. He's in the audience tonight. And if I make a mistake, he's here to straighten me out. In any event, the type of business that my client is in is basically a service rental business. Not only do they sell and service high-lows, or what we would call forklifts, they also service all of the factories in the area with special overhead doors, backup bumpers for tractor trailers when they come in, elevators that bring the floor up and down to meet the tractor trailers. And one of the prerequisites of being in this type of business is having stock. So when someone comes to you around the block or in the same factory area or some other area, and they say, my gear gizmo broke, I need it fixed immediately, we have to have those parts in storage. If not, we would slowly go out of business, because the factory that has the broken forklift doesn't want to wait 2 days for it to come from wherever it comes from. So there was a design made for mezzanine. That's why you see the variance the way it is. The mezzanine is used for storage. It's a steel mezzanine within the interior of the building. Phil Pandolfi again did all the submittals on the structural. If you look at the, again, you look at the site plan, most of the requirement for the parking, the office is very little. It requires basically 28 spaces. It's the warehouse at 1 to 500, which requires all of these additional spaces. The type of business that it's in, that they're in, they need this type of space, as I said, to maintain inventory. It's certainly a service to the community and the factories in the area. They have a substantial use of the property, more warehouse than anything else. They do repairs on the forklifts there, and they do repairs outside of the shop, so to speak, at the factory. So we don't feel this is a substantial request, given the fact of what they do. It really can't be done in any other fashion. If you don't have the warehouse space, and if you don't maintain the parts, you're out of business. And that's the reason why we have these mezzanines. And that's why we're asking this board for a variance. It's kind of different because there's not a bunch of people that are going to be in this property. There are a bunch of equipment, inventory, stuff like that, which has to be stored. So was the difficulty self-created? We're asking this board for the variance. We want to maintain our business in the town of Smithtown, in the industrial park. The owners are local people. They come from Hauppauge. So we ask the board for its favorable consideration.
Mr. Tramarko, we were at the site, and I'm going to turn it over to planning because we have some concerns. So, Allison?
The first question is, when were the mezzanines constructed? Do you know?
Phil? Madam Chair, this is Stephen Lopiccolo,
All right.
one of the owners.
Yeah.
Hi.
Stephen, let me have your address, please.
Home address?
Can, whatever you want.
7 Autumn Drive, Hauppauge, New York.
Right. Raise your right hand. You swear to tell the whole truth and nothing but the truth.
Yes.
Can you answer?
Sure. I purchased the building back, I think, almost 6 years ago now. There were 2 existing mezzanines in the facility already that I didn't know were a problem until I just put one in a few months ago. So that's how this came up.
Okay.
When I put my mezzanine in, I applied for the sprinkler permit, and that's how this all got started.
The other issue that we noticed when we were there is that there's a considerable amount of outdoor storage in the back of the building. And unfortunately, in this zoning district, the light industrial zoning district, outdoor storage is not permitted. So it becomes a question with, can you keep that equipment indoors? Is there space for that storage indoors?
That is one of the reasons I wanted the mezzanine space, to increase the storage inside, yes. Can I ask when you were at the site? Because we did have a bunch of equipment that was lease returns that we had the leasing company take away in the last couple of weeks. So
We were at the site yesterday.
Yesterday.
Okay. So there were probably 8 or 9 machines out back. Okay.
Yeah. The other question I have is that there wasn't too many parking spaces that were empty. And I don't know how you're going to put these parking spaces in the rear unless you remove all that equipment.
Correct. Now, I don't have any more people, so the cars that you saw there are it. I didn't add any more staff by doing this. We just increased our storage inside. So, you know, Phil gave me on the plans to stripe the parking lot, and then instead of having cars parked, maybe the way you saw them, they'll be in spots, a little more organized.
Well, I don't
If
know.
that answers the
Well, that's
question,
not
I
a
don't
fair-
know.
get- Do they have to, put these parking spaces in, I am assuming, am I correct?
When they go through site plan approval, they'll make sure that it's striped the way
That's
that
right.
it's supposed to
Okay.
be.
All right. That's fine. Are there any other questions? Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Really moved in second. All in favor?
Aye.
Aye. Motion carried. The next case, 16566, Francis and Deborah, it's adjourned to February 14th. Okay. The next case is case 16567, Teachers Credit Union. Okay. 2410 North Ocean Avenue. Well, let me do the location. Location is northeast corner of Vanderbilt Motor Parkway and Moorland Drive, Hop Hog Property Zone LI. Request variance to reduce required parking from 2,582 spaces to 1,596 spaces for a proposed 1,200 square foot accessory building.
Good evening, ladies and gentlemen. My name is Tom Fallon. I'm the Executive Vice President and Chief Operating Officer of Teachers Federal Credit Union.
You know what? Take that mic right out there.
Maybe, are you a little smaller than me?
All right. May I have your address, please?
102 Motor Parkway.
Okay. Raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes.
Okay. Now, would you like this gentleman to speak
Yes.
for you?
This is
Okay.
Mr. Rob Morrissey.
Okay.
Thank you.
Okay. Let me have your name and address, please.
Rob Morrissey, 181 East Jericho Turnpike, Mineola, New York.
In the spelling of your last name?
Morrisey.
Okay. Raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
As we said, teachers are seeking a parking variance to accommodate a 1,200 square foot accessory storage structure. The plan for the structure is to store their maintenance vans that they have, which service their branch network. Within those vans, they store a lot of equipment, materials, and whatnot. And just from a security point of view, they don't want to leave them out in the parking lot of the building overnight and on weekends and whatnot. This would be identical to their current or their former condition at their former headquarters in Farmingville. Right now, 102 Motor Parkway, we're in the process of just finishing up the last phase of their complete relocation over there, and the building is about 91% occupied. And then based upon current conversations between teachers and the adjacent owner of 100 Motor Parkway, that building is in between 90 and 95% occupied. I would also like to present, if I may, photographs of the parking areas that I took just the other day.
Just give them to me. I'll pass them out. It's faster. Want to send one down over to Allison, I guess? Here you go.
Again, previously, there has been a variance granted for teachers approximately 6 months ago for 1,600 spaces. And at this point, I guess, while it does seem substantial from the 2,500 to the 1,500 numbers that we were talking about, we're only really talking about 4 more spaces at this point. The garage is going to be located in an area that's taking over 3 real spots and 1 land bank spot. And again, we're creating 3 garage spaces essentially.
Okay. Planning?
The only concern that the planning department has to do with the ingress and egress easement to the Sheridan parking lot.
Okay.
We just want to make sure that that is maintained.
Yes, absolutely. Yeah. We're not, I mean, I know we're opposite it, but we're not doing anything to impact that at all.
Okay, any other questions, gentlemen?
No question.
Nope.
Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second?
Ready, moved in second. All in favor?
Aye.
Aye, motion carried. Okay. Ladies and gentlemen, we'll be going to the adjourned cases. At this point, we'll be taking a 10-minute break. Thank you.
Include travel. You got 30 seconds.
Motion to close. All right. Next, the case 16524 Arthur Avenue is adjourned to January 24th. Case 16526 Joseph Legalbo is adjourned to January 24th. Next case is case 16544 Napatanzis. Location northeast corner of East Main Street, east of Bank Street, Smithtown, property zone CB. Special exception to modify outside dining, increase area from 160 square feet to 320 square feet. Okay.
How you doing?
Let
John-
me have your name and address.
John Gleason, 336 6th Avenue, St. James.
Okay. Raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
Yes, I do.
Okay. You received the PAR today?
I received the PAR yesterday afternoon, reviewed it with the client, and if you look at the item number 6 on page 3, the recommendation we agree with, and items number 1 and 2, as far as the conditions, we agree with too, and will comply with those conditions.
Okay. So you agree with all the conditions?
Correct, yes.
Okay. All right. Now, you know there's no action because I'm still waiting for
the secret.
For a secret.
Right, we're in process with the
Okay.
environmental.
Okay. And so as soon as we get the secret, we'll be voting on this application. Okay?
Very good. I appreciate that. Thank you
You're
very much.
welcome. Planning, anything?
Thank you.
Is there anyone here that would like to be heard on Napatanzis? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second?
Thank you.
Rarely moved in second. All in favor?
Aye.
Aye. Motion carried. Okay. Next few cases, I'll read both cases. Okay. Case 1-16247, Rob Glenn Enterprise, Comac Car Wash, 2207 Jericho Turnpike, Comac. Location, north side of Jericho Turnpike, 144 west of Ruth Boulevard, Comac, property zone WSI. Request modify special exception and variance approvals dated February 22nd, 2011, so as to delete condition number 1, which requires this site and the adjacent site to be designed and used as one site, in particular with regard to parking. Case 1-16305, rehearing, Alfred Properties Corp., Comac Car Wash, location north side of Jericho Turnpike, west of Ruth Boulevard, Comac, property zone WSI. Request to modify special exception and variance approval dated February 22nd, 2011, as to delete condition number 1, which requires this site and the adjacent site to be de-designed and used as one site, particularly with regarding to parking.
Good evening, Madam Chairwoman, members of the board. My name is John Zolo. I'm here this evening on behalf of Rob Glenn Enterprises doing business as Comac Car Wash. First of all, just let me say thank you very much on behalf of my client for agreeing to rehear this case with respect to condition number 1 that was imposed by this board on its decision of February 22nd, 2011. The board, in granting that special exception permit for my client to continue operating the car wash that's been there since 1960. And before I go any further, just let the record reflect that the affidavit of posting has been filed with the clerk, and that previously the affidavit of service and mailing was filed with this board. The condition for which my client is asking to be modified or removed is condition number 1 from this board's grant. Condition number 1 states, because the proposal would make the car wash site smaller than originally approved and smaller than the minimum lot area and the minimum frontage required by the zoning ordinance, the filling station and repair garage uses shall be merged, having cross-access agreements in order to provide adequate parking for all 3 uses. I am here for the car wash tonight, the car wash which has been at this location since 1960. While the site has not changed much, and as this board recalls, the hearing on this case was November 23rd of 2010, so it's almost a year ago to the date that I was here before you for this case. The Comac car wash site has not changed much over the years, but the business has. From what was a thriving car wash, and you might recall over the years seeing cars backed up on Jericho Turnpike and people waiting to get in to have their cars cleaned, that no longer happens. The car wash business has changed dramatically. A large bulk of my client's business, as you had heard in the past through testimony of Bruce Klein and other witnesses on behalf of the applicant, the business has changed, and now a large bulk of the business performed by my client at the site is not just a car wash, it's detailing, wholesale car detailing, a process that's controlled by my client, the owner of the car wash. They bring the cars in and they take them out. It's a controlled business. The board, by imposing this condition, has put my client at the mercy of the landlord. We cannot count on the landlord's cooperation to preserve my client's rights, and as a consequence of this decision, with respect to condition number 1, on behalf of my client, Comac Car Wash, I was forced to initiate an action in Supreme Court, Suffolk County, under index number 11-12795, basically to preserve the status quo while we clarified and hopefully convinced this board to modify its decision. The board, and I do appreciate it, in attempting to craft a decision that benefits or works for all parties, has imposed condition number 1 that puts my client at the mercy of the landlord. The landlord is not giving the cross-access easement or the cross-access agreement. The fence that was to be removed is still up. I do not believe it's coming down anytime soon. As this board may recall, in the planning advisory report that was prepared by Ms. Charles, she had suggested that a permanent parking easement be granted from the landlord to the car wash for 8 stalls on the western portion of the site. Fortunately for my client and the landlord, this board thought better and did not impose that permanent easement condition. What you did do is require cross-access, which, although not as severe as a permanent easement, is still not going to happen. It's not going to occur, and it puts my car wash, my client's car wash, in jeopardy. I am not here to cast aspersions upon the landlord or attack the landlord's motives. This board, by imposing this condition of cooperation, has put my client in a difficult and untenable position. Without the cooperation of the landlord, we can never satisfy condition number 1, which talks about adequate parking on the site. And that's what that condition was set up for, and put in there for. The issue is parking. By letters to this board dated May 25th, 2011, and August 25th, 2011, I laid out the basis to support my client's contention that there is, in fact, adequate parking on the site. and I beg the board's indulgence. I would just like to read that letter into the record. Dated May 25th, 2011. Dear Ms. Chairman Jandeo, members of the board. As you know, I represent Rob Glenn Enterprises, doing business as Comac Car Wash. The car wash, as this board is aware, is a tenant on a portion of property owned by Alfred Properties. The overall property consists of one site with 3 uses. On February 22nd, 2011, this board rendered 2 decisions affecting this one site. The decision on behalf of the car wash is identified as BZA case number 16247. The decision involving Alfred Properties is identified as BZA case number 16305. Counsel for the landlord and I have discussed the implications of the board's decision and have tried to reach a workable solution that would accommodate the concerns raised by the board regarding the cross-access agreement that would ostensibly require the landlord to make 8 parking spaces located on property that is not leased by the car wash available for use by the car wash. That would be condition number 1 in both decisions. The landlord's counsel recently indicated that his client will elect to forego the benefit of the zoning board's grant rather than comply with condition number 1, which the landlord believes will significantly impact the marketability and value of the balance of the property. While the car wash is not able to comply with the letter of condition number 1, it was able to reconfigure the site plan to comply with the spirit of the condition. Specifically, it was able to reconfigure the site plan to create a total of 19 parking spaces on the site. This includes 3 parking spaces for cars parking in the detailing bays. This being the case, assuming that this board is willing to accept the additional parking spaces as delineated by the car wash, then the car wash should only be shy 1 parking space to satisfy the desires expressed by the Board of Zoning Appeals and its findings. At the hearing before this board on September 23rd, 2010, I presented a site plan dated February 17, 2010, which showed all structures removed. The site plan depicted the site as it currently exists. On the current site plan, the car wash is able to identify 19 parking spaces. As this board is aware, the car wash business has changed dramatically over the past 6 years. And this board is also aware that the photos and aerials that the planning department referenced during the hearing of November 23, 2010 were taken sometime in 2004. The 2004 photos showed structures that no longer existed on the property. This board, although not stated as a condition in its decision, is asking the car wash to locate an additional 8 parking stalls on the car wash site. After reviewing the minutes of the hearing, I was somewhat troubled by the comments made at the hearing by Ms. Charles asking the applicant to submit a plan that shows parking. The applicant had submitted to the planning department well in advance of the hearing the February 7, 2010 plans showing additional parking on the property. The provision of the zoning ordinance regarding parking for car wash is extremely vague and ambiguous. Even on the night of the hearing, the determination concerning what the parking calculations were for the car wash was recognized as vague and subjective. The ordinance states that the parking shall be adequate. It is submitted to the board for its consideration that the car wash can demonstrate an additional 7 parking stalls on site, including 3 bays. These additional parking stalls, only 1 shy of the number determined by the board to be adequate, should satisfy the board's concerns. There is no hard and fast rule with respect to parking calculations for a car wash. The car wash owner knows best what parking is required for its business and how best to accommodate the parking needs for its business while making certain that the overall site is not unnecessarily congested. The car wash is willing to limit the number of vehicles parked on its portion of the site at any one time. The suggested number of vehicles that could be parked on the site at any one time, not including cars in queue for the car wash, is 17. This number is arrived at by incorporating the 14 stalls plus the 3 cars in the detailing bay. Based upon the reconfiguration of the site and through a review of the board's findings and decision with conditions, it is respectfully requested that this board eliminate condition number 1 from its decision in BZA cases 16247 and 16305, seeking a cross-access agreement, and determine that there is adequate parking on the portion of the site leased by the car wash for the car wash use. This request is made with understanding that the car wash can establish adequate parking on its portion of the site by providing 19 parking spaces. Based upon the foregoing, respectfully requested that the board modify its decision in BZA case numbers 16247 and 16305 dated February 22nd, 2011 by eliminating condition number 1 in each decision and determining that a cross-access agreement is not necessary and that the parking on the portion of the site leased by the car wash is adequate for the car wash use and is otherwise consistent with all applicable provisions of the Town of Smithtown zoning ordinance. Thank you for your indulgence. You should have, I had sent this letter to the board previously, but one of the things I wanted to make sure the board knew, it was troubling to me, and I said it at the hearing we had last year, I had submitted, at the request of Ms. Charles, the site plan showing 12 parking stalls on the property. I'm going to give you the copies of what I had submitted, so each have one.
I'll take these.
The site plan of February 17, 2010 shows 12 parking stalls. The entire middle of the car wash is vacant on the site plan. The proposal, as I suggested, is we can, I think, clearly and easily show you additional 4 stalls in the middle of that paved area on the site. We had 3 cars in the bay, 12 were shown on the plan, and we put 4 additional cars in the middle. We now have 19 cars parked on the site. You must understand that the business of the car wash is that the only cars that are moving on the site are the car wash, people coming in for the car wash. All the other vehicles, except for a handful of the 3 vehicles that the town had previously identified as for the employees, those are moved when the owner decides it's time to get cars from a dealership, bring them in and bring them in for detailing. They control the flow of the cars on the vehicle. There are no other vehicles that are being moved on the site other than those that are being detailed and picked up and delivered from dealership to the car wash and car wash back to the dealership. Again, all of that is controlled by the car wash. And also understand that the owner does not want to create a congested site because it takes that much more effort to move vehicles on or off the site if you have to basically handle it like a parking lot in the city where the cars have to come in and out, and that's not their intention here. We're willing to, as we stated back at the hearing last year, and I'm saying again tonight, we're willing to limit the number of cars that can be parked on the site. I propose 17. That would be 3 in the bay, 3 for employees, and 12 on the rest of the site. And it works. But I want you to know that this was presented when the application was filed. This was provided prior to the hearing of November 23rd last year. And again, it was delivered back to the board at the request of this board back to Gloria Charles the day after the hearing. So this has been around. This is what we're relying on. It was just troubling to hear that at the last meeting of November 2010. And also that you looked at aerial photos concerning parking in the front there from 2004. No one knows where the complaints for the car wash came from, but they were here. There has not been parking in that front apron area. My client's doing everything they can do to avoid problems with the town, avoid problems with the landlord, and just stay in business. Next, I have some photos for you. I've just presented the chairwoman with large photos, 4 large photos. Those photos were taken last year in November. And they show, if you look at the photos, you'll see 9 cars parked on the site. 3 in the bay, 3 to the north of the bays, and 3 to the south in a row along the building. Looking at that photo, you see 9 cars parked on the site.
This way.
I've also given you some smaller photos which were taken last Friday. I took those photos unannounced. I didn't go the Thursday because it was raining, so I wanted to get some activity at the car wash. I took the photos, and as you could see, there were cars coming out of the car wash. There were 6 cars parked in the lot towards the front, and behind those cars is an open, empty lot, and there's 3 cars in the bay. I'm giving you those photos because if you look at them, you have to recognize with the nature of this business that what's proposed for this site is a parking of 17 cars, 3 in the bay and 14 on the site. The site can handle it, it's adequate, and the nature of the business it's able to accommodate it, and it just makes sense. In none of the photos, which are taken during normal business hours, are there 12 cars on the lot.
Here's the other ones. Here you go.
My clients are willing to agree not to park more than 12 cars on the site for detailing, 3 in the bay. That's a total of 15 cars. And if you give us the 3 for the employees, a total of 18. But my client can handle and will accommodate and accept a reasonable parking condition from this board. And when we go to parking, a car wash is subject to general exception standards. And I'm just going to go over that briefly because that's where the problem arose. General exception 322-94G, special exception standards. For a car wash, there are none except the general standards. If you look at page 3 of the findings, it talks about the criteria. It's a gut feeling. The requirement for parking is vague. It's not specific. The only person who really has a sense of what's right for this parcel, for this parking on this property, is the one who operates the business. The number that was arrived at, as Ms. Charles indicated, was kind of just what they thought was right. But I'm explaining to this board, and I hope the board understands that this business, what we have on the site and what's provided for parking is adequate. The standards for parking are general, amorphous. They're not for specific uses, and the owner does not want a congested site. They have to work on it. There is no sidewalk parking on the site, and there's no car spilling over on Jericho. Those days are gone. I think I've hit to this board all the concerns we have. I'm asking you to remove condition number 1 for 2 reasons. My client is able to establish adequate parking on the site. And the second, more important reason is we are never going to get a cross-access agreement. And by imposing that, you have sounded the death knell for my client and Comac Car Wash.
Okay.
So I'm asking you to look favorably upon this request and remove condition number 1. Thank you for your time.
Thank you. Okay. Is there anyone that would like to be heard on this application? Come up, please.
Thank you, Madam Chair and members of the board. My name is Anthony Guardino. I'm an attorney with the law firm of Farrell, Fritz in Uniondale, New York. I represent the landlord here with the applicant in the other application. I just would like to hand in my. I will be very brief. I want to start off by saying that I join in the request made by Mr. Zollo on behalf of his client to have condition number 1 from the grant removed. However, I do object to the comment that Mr. Zollo made that the landlord is not cooperating. That is clearly not the case here. The landlord could have withheld consent to the car wash's application, and we would not even be here today. But what the landlord said was they would consent to the application and allow the car wash to obtain whatever relief it could get to allow its operation to function within the leased area. In other words, to stay in its box. It has a leased area that it has leased for many, many years. And what has happened over the years, and I think you're all aware of it as local residents, the business, perhaps when it was doing better, the operation spilled out beyond the leased area. It spilled out onto the road, as was mentioned earlier. I remember when the line used to go around onto Ruth Boulevard. around from Jericho Turnpike. It also now spills out occasionally when they dry the cars, it spills out onto the remainder of my client's site. So my client has in fact cooperated by allowing the applicant to even come forward and obtain whatever relief that it needs in order to make its business function within its property area. And I believe the board even mentioned in its decision that there was this box that they would either get the relief or cooperation from the landlord to add additional parking and cross access easements, or they would have to stay in their box. My client's position is they need to stay in their box. So my client is not interested in granting any type of cross access with the car wash. As I mentioned at the hearing back in November, my client is actively trying to market the space. There are 2 other buildings on the property, as you know, that have been vacant for many, many years. It's an eyesore, and the landlord wants to have the property redeveloped. I know the town, I'm sure, wants to have the property redeveloped. What will happen here, if the landlord were to consent to that condition, would be that you'd have a situation where you essentially have the tail wagging the dog, because as Mr. McCarthy, who is the broker on this property, can testify if he is so inclined, people who are interested in the property, they want to know that the property is theirs and theirs alone to use. What would happen here is you're going to end up with cars being dried in the parking lot of whatever the use is. And I don't know what the use would be, but whatever the retail use would be, I assume it would be some kind of retail use. Arguably, once you have a cross-access easement, the car wash can park the cars after the cars come out of the wash, and they could park over there because they'd have a right to. Quite frankly, they'd have a right to. And that's not something that enhances the value of this property and quite frankly, significantly and adversely impacts the marketability of the property. So that is why the landlord is not inclined to work with the landlord on that particular condition. It's important because it actually will go to the very marketability of the remainder of the property, and I don't think that's in anybody's interest. And I have nothing further at this point.
Thank you.
Thank you.
Okay. Anyone else? Good. Good.
Sure. I guess you're very good at zoning law, obviously. The question I have for you is, if down the road your client proposes a use on the site adjacent that may be over intense for that site, would they be requesting from us to look at this site as a whole at that point? Because we don't look at it as 2 parcels, we look at it as 1 parcel from where we sit.
Right. No, we would not. I mean, what's good for the goose is good for the gander. I mean, if they have to stay in their box, we would have to stay in our box.
Okay. Thank you.
So
Okay.
that's a legal term.
Yeah. Yeah. Okay. All right.
Thank you.
Is there anyone else? All right. I'll entertain a motion to planning. Was there anything that you needed to?
Just one question. Mr. Zolo, when you had said that they're now keeping all the cars on the site. Is there any chance, or what's the risk that the business expands more than what they're doing right now, and where to the point they would be bringing more cars on?
There is no risk of that. My clients are respectful of their obligations to comply with the town code, and this board sees fit to remove condition number 1. They will honor that, and they will abide by their obligation not to exceed the number of vehicles allowed on the property. So there's no risk of that. Because without that grant, this car wash will probably no longer exist.
Thank you. All right. I'll entertain a motion to close the hearing.
So moved. Second.
Really moved in second. All in favor?
Aye.
Aye. Motion carried. Thank you. Good night. That concludes our hearings for tonight. Thank you so much.